No major rulings from the Supreme Court today as we continue to wait for decisions on same-sex marriage and affirmative action, but we did get a couple of interesting decisions. Court ruling 5-3 in a case that will limit some class action lawsuits. Those are suits where a number of people join up in one big lawsuit. The case pitted merchants against American Express. The merchants, as part of their deal with Amex, had agreed to arbitration to settle any disputes, and they signed off in writing on their right to join class action suits. But later, when they accused Amex of inflating their fees, they did join up and sue, saying, hey, none of us have the power or the money to take on American Express all by ourselves. The court today held for Amex and said those contracts, including the no class action clauses, must remain in effect. And Mark, you're the expert when it comes to the court. First of all, was it a fairly accurate summary that I just gave? Let's start there.
No big decisions, so you're foisting these dogs off on me. Thanks a lot.
Well, you'll be back for the big ones as well. What about the main argument from the defendants that, you know what, I'm not big enough to take on American Express or Apple or Microsoft, so if they do me wrong, I do need to...
It doesn't preclude them from bringing suit against American Express.
But they have to do it by themselves.
It precludes them from bringing a class action arbitration against American Express. So, you know, arbitration is a creature of contract. You create your arbitration rights by contract. That's the agreement they entered into. It's a pro-business court and an opinion written by Scalia. It's not a surprising decision, split along the usual ideological lines. And I don't know about you, but most small merchants that I go to, I try to give them my American Express card and they say, see you later, take a hike, pal. So if you don't want to deal with Amex and the 3% markup on the credit card, just don't do it.
So now, you know, when you sign up for a credit card, you get a list of like 30 pages of documents that you have to sign. And what's to say going forward that somewhere in there isn't going to be a clause that says, you know what, you can't gang up for a class action arbitration or lawsuit?
They could do that, and it would likely be upheld. I mean, you know, you can opt out of it and not sign it. But, you know, the fact of the matter is we're living in an era of an increasing corporatization. It's a one corporation world, and if you want to deal with that one corporation, you're mostly at their mercy. And as we said off camera before, these are what are known in the law oftentimes as contracts of adhesion. You're forced to take it or leave it, and that's the way it is.
Pro-business climate, but isn't it a clear-cut example? I mean, you know what you signed when you agreed to this. How can you flip the script in the middle of the deal?
And the concern I would have is that it allows someone to give up rights to seek justice in the courts that they would otherwise be able to seek. And in this case, where arbitration is precluded from actually occurring, the economic drain on the folks that are bringing the action often has a chilling effect.
And
that's the reality of it. Yeah.
One concern I have is, do people actually know? I mean, you mentioned the 30 pages. It's often in like size 4 font, and people, you know, who actually reads those agreements? I mean, you should, I agree with you, but do people know enough to opt out?
I suspect that the merchants who enter into credit card agreements with Amex read the agreements. I actually suspect that. It's not like the iTunes thing.
You know, to an individual level, I wonder, because I have to say, I don't always read. You can't always read them.
Right.
They're 30 pages of 4 font. I mean,
well, not only that, you know, more pertinent to this, and this will end up in the Supreme Court next term, I predict. You can get federally criminally prosecuted for violating internet terms of service use. And, you know, you can do hard jail time for that. And that is an issue that's percolating in the federal courts in this country that's very likely to get up into the court in the next term.
It's good to be a business these days. Another ruling announced today making it harder for the government to use the details of a previous criminal conviction to add to a federal criminal sentence. The 8-1 ruling applies to how a California judge determined a convict had 3 prior violent felonies. One of the felonies the judge cited was a burglary, which in some cases can be considered a violent crime. But in this case, the high court disagreed. And Mark, I'm just curious, is this a very specific ruling, or will this apply to other people in other cases?
Well, the methodology espoused by the ruling will have a broad application in a way that's too detailed, actually, for me to get into here. But it doesn't make a whole lot of difference in a sense that our viewers would understand. Basically, it makes it a little bit harder to count certain kinds of prior offenses as strikes. Under 3 strikes, you're outlaw laws, and those jack up the penalties for 3-time offenders, oftentimes to life imprisonment.
Okay, not sure how many 2-time offenders are watching tonight, so we're going to move right on to our third story, which is an unusual one, because normally we won't cover a Supreme Court case from another country. We have enough trouble covering the ones from our country. But we got a good one today from London. The UK Supreme Court deciding today that the families of some British soldiers who were killed or injured in Iraq can sue the British government for failing to protect them. One case involved a soldier killed by friendly fire. The other was killed in a roadside bomb attack. The family say the government didn't protect their soldiers properly or provide armored vehicles or other gear. The government had two arguments: that the soldiers were outside of British jurisdiction, and the court said no, and that combat immunity should apply. Basically, that what happens on a battlefield should stay there and can't be argued in court. The top UK court disagreed, paving the way for a trial. And Mark, I'm just curious, military family in the United States can't sue the federal government for...
It sounds like an assumed risk to me, but we have a.
It's a
not
different
a
system.
conscription army anymore, but I mean, this smacks to me of revisionism. It's a war that, in retrospect, was deeply unpopular, and they want to eradicate all vestiges of it. It sounds like a Soviet-era textbook to me. Pretend it didn't happen, and at the same time, placate certain restive elements of the British population. So this just seems a palpably politically motivated kind of ruling. It's absurd.
I want to open this up to the full panel because we had American soldiers in Iraq and Afghanistan who were killed by roadside bomb attacks, and they were begging and pleading for plating, armor plating on the side of their cars. Should soldiers and their families have the right to sue the federal government if they're not protected in combat?
What comes to mind to me, I say bravo to these British citizens that can sue. But what stalks and the total opposite is here we are in America, and you can't sue gun manufacturers. You know, so you can't sue gunmen. They have immunity, but now soldiers in Britain or in England can sue. I mean,
It seems incredibly just that they would have the right to sue and completely untenable as national policy.
You can sue individuals here in this country in their individual capacity if they act outside the scope of their duties. For example, the Supreme Court, our Supreme Court, held this term that you can sue an Army doctor for indifference to medical needs. So you can sue somebody individually. You can't sue the government as government. It just doesn't work that way unless the government waives its immunity, which no commander-in-chief is ever going to do. So.
I'm curious because I feel for those families. If they feel like their kids weren't being protected, then they should have the right to seek justice. But at the same time, I think Scott's right. This would be an incredibly difficult policy to put in place.
Yeah, I mean, I think we all feel for the families, and you feel for the victims and everybody who was involved in war in any capacity. But by the same token, how can soldiers sue, or families of soldiers who are injured sue the federal government? It would be, as you mentioned, untenable national policy. The government simply, the U.S. government, I can't imagine would ever allow something like that, and you would have to have it allowable.
I mean, can you imagine people suing the United States for what happened on Omaha Beach, that they weren't properly protected? I mean, this is something that's even fathomable.
But let's take the other example of when folks in supervisory positions, commanders and chiefs, folks knew people were being put in danger and put them in danger again and again and again when they could have avoided that danger with either a movement of government pen or a shift of a policy.
That's the let's sue George Bush for declaring war on Iraq in the first place.
That's,
I mean,
what that's what this is.
But you
The
really,
British
that
equivalent
you
of it,
absolutely, like, there's no way that, I mean, that's...
The whole purpose of immunity statutes is to protect people from having their decision-making authority chilled by the threat of lawsuits. I mean, the fog of war is a cliche for a reason. The decision was ratified by Congress, rightly or wrongly. He didn't act outside the scope of his authority. It's a legitimately authorized war. Was it smart policy? I don't know, but you don't eradicate it by lawsuit afterwards, by post hoc lawsuit.
All right, we're going to shift next to a topic that really requires no debate as we bid a fond farewell to New Jersey's own James Gandolfini. Stay with us.